Assalamualaikum warahmatullahi wabarakatuh. To our respected lecturer, Miss Siti Hajar Muhammad Hussein. My name is IZZATI binti AHMAD HISHAM, student number 2018801166. Our group will present about the case study of trade disputes between Malaysia Airlines System Employees Union Peninsular Malaysia (MASEU) and the Employer Malaysia Airlines System BERHAD. I will present the introduction part. The case was held in Industrial Court located at Kuala Lumpur. The representative for MASEU was Mr. Fu Kun Sing, while the counsel for MAS was Mr. Vijayan Venugopal from a legal service company. Although the reference was made on 2015, the complaint submitted by MASEU was way back in February 2014. The final order was made by the chairman of Industrial Court Malaysia, Yang Arif Tuan Rajendran Nayagam, on 4 June 2018. Based on Section 2 of the Trade Union Act 1959, both employer and employee can set up their own association or join a union, but it will be limited to the place that they are currently working.
My name is Norhasyikin binti Asri. My student ID is 2018205934. I will proceed with the main context is the trade dispute between Malaysian Airline System Employees Union Malaysian MASEU and Malaysian Airline System BERHAD MAS. The claims had been made on 31st March 2015 pertaining to trade dispute relates to insufficient payments made by the company in lieu of annual leave in respect of unutilized annual leave of 1,452 cabin crew members. Since the dispute was still unsettled, the trade union made a reference as a trade dispute exists to Industrial Court on 31st March 2015 as stipulated under Section 26 subsection 1 and Section 26 subsection 2 of the Industrial Relations Act 1967.
Assalamualaikum warahmatullahi wabarakatuh. My name is NAJWA binti HASSAN and my ID number is 2018660312. So for the next part, I will explain the reply from the union, which is the Malaysian Airline System Employees Union. Based on the case, the representative of the union was defending that they have right for local study as a party, and they also compared their situation with the two previous cases, which is the first case is the Era Engineering Pressworks Indian BERHAD versus Kesatuan Kebangsaan Pekerja-Pekerja Perusahaan Alat-Alat Pengangkutan dan Sekutu, and another on 2001. The second case is Kesatuan Kebangsaan Pekerja-Pekerja Perdagangan NUCW versus NISO EY Corporation and Sojix Corporation on 2008. As for the first case, the High Court stated that the company was still operating and exists at the time the complaint is made and when the hearing came up. Meanwhile, for the second case, Industrial Court has found that the person named Lee was the represented by the union at that time had retired from the company, and it turns out that the Lee was also terminated as a union member. Then it should become a reason why the Industrial Court has dismissed the case, as the union has no right to become a party as the person was no longer a union member. It can be referred to the Industrial Relations Act 1967 under Section 2 that defines the party regarding a trade dispute as to that the trade union that acting for all or some of its members in a trade dispute. The union has compared their case with both of the cases in which they stated that the company has ceased all operations on 1st September 2015, which is after they made a complaint to the Director General. In other words, they still have the right to local study and to appear as a party that represents the 1,452 cabin crew employees of the defunct company. So we move on to the next part, which is regarding the local study issue. Based on the case, it states that in order to consider the local study issue, they need to consider the reference to trade dispute first. The Industrial Relations Act 1967 under Section 26 subsection 2 defines the trade dispute as to any conflict between an employer and its employees relating to jobs or non-employment, to the terms and conditions of employment, or the working conditions of any other worker. Based on the reference, the union has appeared as a party to the industrial court in order to claim the trade dispute on behalf of 1,452 cabin crew employees which the company has seized. They also refer to the IR Act 1967 under Section 2 to determine who can be a party concerning a trade dispute, as I mentioned before in the previous part, and to at some point, the parties involved in the trade dispute can only be one side, which the company that involved in disputes, and the other one is the trade union, which represents for all or some of the members that involved in the dispute, and it makes the union is so important and necessary in this trade dispute. In other words, the union is legal to appear as a party as they are representing the 1,452 cabin crew employees in the trade dispute. The case began on 26 February 2014 when the company, which is Malaysia Airlines System BERHAD MAS, still existed, and the union was at that time was the in-house union and was still a member of a union. They made a complaint regarding a trade dispute issue, and according to IR Act, under Section 18, Subsection 1, Subsection A and Subsection B, that states that if there any trade dispute that cannot be solved, then it may be reported to the Director General, and it may be reported by a party, whether an employer or a trade union of employer that representing the employer in the disputes, or may be reported by a trade union that represents the employees that involved in the dispute. On 31st March 2015, the case was referred as a trade dispute to the IR Court, and it was pending until 25th May 2018 when the hearing was coming, and on that time the company MAS has ceased its operations on 1st September 2015, which before the hearing. An issue arises when the union claims that they still have 11 members of the union who pays the fee to represent the 1,452 cabin crew. Unfortunately, when they refer back to the Rule 3.1 of the Constitution of the Union, the rule carries the meaning where the 11 members are no longer a union member, as they also have been terminated when the company has ceased. And according to Section 2 under IR Act, they no longer able to appear as a party under Section 18 subsection 1 that stated during temporary union awaits for a trade dispute, the union must have members from the company and remain as an employee and union member. Lastly, in order to further support that statement, they have referred to the previous case that has the same situation as the present case, which is Dunlop Agro Management Sdn Bhd versus Association of West Malaysian Plantation Executive in 1993. The President has dismissed the case and the union submission as the union has no longer standing to represent the employees, as there is no longer a member in the union.
Present the timeline of MASEU versus MAS case with Norhasyikin. On 26 February of 2014, the union issued a complaint to the Director General of Industrial Relations about the unresolved dispute. Next, a reference was made on a trade dispute to Industrial Court on 31st March 2015. On 1st September 2015, MAS operations suddenly came to an end and all of the employees were legally terminated. The trade union MASEU status that previously representing the employees as the in-house union suddenly became unclear. Thus, the union's local standby to appear as a party in the trade dispute with MAS also become questionable. On 25th May 2018, the hearing was held after almost 3 years of awaiting and complicated the process because the hearing happened years after MAS was gone, indicating there was no longer workmen working for the company at the time of.
As the in-house union that the members were the employee in MAS company, if the company are dissolving automatically, the members of the employees in union will be cancelled and they can't do the claims to other party and need to wait the decision from the court regarding the dispute problem. The union tried to their defense by refer to the two cases, Iraq Engineering Press Works Sdn Bhd versus Kesatuan Kebangsaan Pekerja-Pekerja Perusahaan Alat-Alat Pengangkutan dan Sekutu dan Anno 2001 and Kesatuan Kebangsaan Pekerja Perdagangan NUCW versus NISO EY Corporation and Sojitz Corporation 2008 that had a similar case. The question is whether the union had their locus standi to espouse the claims of the 1,452 person as only 11 members that active and paid the fee of the union. The union actually are not remained as a union because of the company dissolved that automatically changed the situation of the in-house union because they need to remain as a member during the complaint made and the process of hearing.
As for the recommendation, regarding to the case, firstly, in our opinion, the union must act immediately, such as in the process gathering evidence if there was a dispute in the company. And also try to discuss as best as the union can and try to find a solution while negotiating with the company, and if there was still no solution and found a dead end, then they may make a complaint to the Director General. This is because there is a high possibility for unwanted things to happen, and one of it was the company has ceased its operation before the case is settled and finds a solution. As a conclusion, the court had decided that the union don't have the locus standi to expose the claim of the dismissed 1,452 cabin crew members and the defunct of the company must that made the union lost their locus standi to claims as the party, and the claim is dismissed. It refers to where the 11 people who pay the union's fee are disqualified to represent the 1,452 cabin crew, as they are no longer part of the union, as the union has ceased automatically when the company must has ceased its operation. It causes that the union no longer able to be a party, and indirectly the union also are disqualified for the locus standi supported by Section 2 and Section 18, Subsection 1 under Industrial Relations Act 1967.